Hi, I'm Zach Anderson, owner of Valley Estate and Elder Law, and I wanted to take just a few minutes to tell you about how your initial consultation for estate planning will go with our office. The goal of this video is to allow you to prepare for that appointment so that you get the most out of it that you can. And while we don't bill hourly, we want to respect your time. We know you're busy, you might be caring for an aging loved one or have jobs, community, and things like that. So we want you to be able to watch this video and learn a little bit ahead of your consultation. We know in this area, I've lived in this area since I was 3 months old. We've got a lot of planners. I'm one of them. We got a lot of people that like education. I consider myself to be a nerd. Maybe you're the same way. So that's the goal here. First, to kind of deflate some of the pressure about how things will go, the consultation will probably be more substantive than you expect, but also more laid back than you expect. Hopefully, it's more substantive than you expect because we love hearing, and we usually hear at a consultation, we love hearing from you or your advisor or your spouse or whomever, oh, I had never thought of it that way before, or something like that. So hopefully it's more substantive than you expect. I can almost guarantee you it's going to be more laid back than you expect. We have plenty of easy, flat parking at our office, and your estate planning attorney handling the consultation, working with you, is going to be dressed similar to how I'm dressed, business casual or what have you. We don't love three-piece suits with lots of starch that look like they were out of the year 1850. That's not really the style that we're going for. So there's three things that I want to educate you on and let you learn about before your consultation in this video. And the first is, I put up three fingers. We're only on number one. Settle in. The first thing is the low-hanging fruit. The low-hanging fruit in estate planning is incapacity planning, okay? It's taking care of you if you can't take care of yourself. We have clients that have really high estate planning needs, like maybe they have an ongoing business, they're worried about a child receiving an inheritance, they have lots of different varied assets, they have maybe a rental, an ongoing business, and a brokerage account with $1 million in there, and maybe they're a blended family, they have stepchildren, really high needs in estate planning, and they don't have a living will, okay? So we don't skip the low-hanging fruit. And the low-hanging fruit in estate planning is taking care of you when you can't take care of yourself. We're not talking about after death. Taking care of you if you can't take care of yourself. And what does that look like for you? What can you be thinking of even before your appointment with regard to this? Nominating surrogate decision makers. That's the first thing. So you, right now, while you're alive and healthy, nominating people to make decisions for you if you can't make decisions for yourself. The tools we use here, the familiar ones, powers of attorney, advanced directives, things like that. But ahead of your appointment, be thinking of, if I can't manage my affairs, who do I want to do that for me? And you may say, oh, easy, my spouse. Great, that's a great start. What if your spouse can't do it? That's going to be my follow-up question. So you could think about that. It could be a sibling, a parent, an adult child, or someone at church, someone at work, a super close friend, or someone like that. The second thing you can think of with regard to this low-hanging fruit is end-of-life wishes. If you are in a medically established irreversible coma or something like that, do you want your life to be sustained at all costs, or do you want to be kept comfortable but have that life-sustaining treatment cease? So you could be thinking about that ahead of your appointment. That would be very helpful as well. Just an interesting note here, incapacity planning does not change based on net worth. So you could be worth $100 million or $100, and everybody needs incapacity planning, and the tools we use for that and the structure and what you can do under the law doesn't really change from client to client. Just kind of an interesting note there. So that was the first thing, is the low-hanging fruit. The second thing is about estate planning generally. About estate planning generally, there are 4 tools that you can use to run your estate plan, okay? And I'm gonna go over those 4 right now. The first is a will. The second is a revocable trust, often called a revocable living trust. The third is an irrevocable trust. And the fourth is nothing. Nothing is bad, okay? We're gonna take that off the board. We don't want to pass away with nothing in place. That is a horrendous option. It will not be fun for your family, and your legacy will probably be a disaster. You're seeing us to make sure that's not the case. So I'm not going to talk about number 4 there. So we've got 3 tools that we can use to accomplish our estate planning goals, and I want to just briefly educate you on those 3. Now, which is right for you? We'll go over that at the consultation. We'll provide some analysis. You'll educate us on your family, assets, decision makers, dynamics, what we got going on. We'll educate you on the law and what we've seen on our experience, what works well, and this, that, or the other. But I'm going to go ahead and educate you on the 3 different tools. The first, the will. Wills can be a complete estate plan, and they can be a completely fine estate plan. The thing about the will is that it is designed to go through probate. Wills don't do anything until they go through probate. So if avoiding probate is a goal for you, a will might not be the best tool for you and your family. Now, who might a will-based plan be appropriate for? Someone who maybe they have a house, a bank account, or a brokerage account that has beneficiary designations on it, and they're fine with that. Their kids are mature, they don't have any stepchildren, not a blended family, and they're not really worried about long-term care costs. Maybe you have the most robust long-term care insurance policy that you can buy on the market. Maybe it's got lifetime benefits. There are a couple of products like that. We don't sell them, but I'm educated on them, and I was happy to go through that education. So that might be a will-based plan that makes sense. We'll return to that example of that hypothetical client in just a few minutes. The second tool is the revocable living trust. The revocable living trust is the most popular kind of trust in America. It is designed to keep you and your spouse, if you're married, in control of your assets for as long as you're alive and capable. You have capacity. It is not one of these trusts where we're deeding property to the kids or we're putting money in a trust that the kids control. That's not what this is. The revocable living trust keeps you in control of your assets, and it has no change in life, okay? So you have no extra taxes, no separate tax return. You do not have ongoing maintenance fees with this type of trust. Once you get it set up, it does take a little bit of work to set it up, but that's what we help with. Once you set it up, it's not really something that requires a whole lot of thought after that until you want to update or check in, which is a good idea. But once they're done, they're just pretty easy. There's no maintenance costs and things like that. No extra taxes, no extra tax return. You get the idea. The third tool is the irrevocable trust. And the irrevocable trust we see used primarily in 2 instances. The first is ultra high net worth planning. Now, I don't like putting a number on this, but I'm going to try and do it anyway. At what number might we look at an irrevocable trust or irrevocable trusts to run our estate plans through? Generally, for married couples, probably $20 million and up. And for unmarried clients, $10 to $12 million and up is when we start looking at maybe an irrevocable trust being a good tool to use for your estate planning. That's the first instance. Those are very, very rare. I guess we're a bit too casual. Like I mentioned the dress code earlier in our firm, maybe our dress code is a little bit too casual to attract a lot of those clients, the billionaires and people like that. We don't tend to work with a whole lot of them. The second type of situation, type of client avatar that an irrevocable trust might make sense for is Medicaid pre-planning. That is protecting the home from long-term care costs eating it up, from the nursing home Medicaid lien attaching to the house after death, protecting the home from that. In that instance, we might use an irrevocable trust. So to go back to my example earlier, that client that has a house, a brokerage account with beneficiary designations on it, and not a whole lot else, if that client was concerned about protecting the home from long-term care costs, maybe their right tool for estate planning transforms from a will-based plan into an irrevocable trust-based estate plan. And again, walking through that analysis, that's what we're here for. That's what your consultation is going to kick off the process for. But that's an example of when that might happen. Now, again, the drawbacks and pros and cons of each, that's what we talk about in the consultation. Okay, so no need to, don't confuse this video with a consultation. This is prepping the preppers for the planning consultation. Okay, so we've got some other videos on our website if you want to learn more about that. The third point I want to bring up to you on this video is that trusts must be funded. Okay, we have an entire YouTube video where we just go into what is trust funding. It's only about 7 minutes long. It's shorter than this video. But trust must be funded. What that means is a trust is only as good as what you put in it. Okay? The most beautiful trust ever that does everything you want and encapsulates all your goals, at the point you sign it, it actually doesn't, it's not worth the paper it took to print that on, believe it or not, because that trust doesn't control anything. Now, if we write a beautiful trust for you and we put your Morgan Stanley brokerage account in there, we just did really powerful planning. All those protections that we built into the trust for spouse, kids, or loved ones, or whomever, long-term care cost protection, what have you, like we talked about earlier, well, we just made the brokerage account like that. We just put that asset, we just protected that asset. Not to mention, we just avoided probate for that asset as well. So what does that mean? It means when our team helps you with the trust, we're sort of maybe halfway there at that point. We have to coordinate your assets with that trust. It may mean putting that asset into that trust now, like the home. It may be keeping that asset out of the trust forever. Sometimes we do that with IRAs and 401ks, for example. But the point here is that it's not just the documents that our team helps you with. Because we've had plans come in that we've reviewed that the setup with the estate planning professional, sometimes it's not even a lawyer that does this, the estate planning professional said, oh, we'll give you the trust, but it's on you. You got to do your own deed and things like that. In my experience, recording the deed is something that can get messed up. Forget knowing to draft it and that we have to draft it properly and getting it drafted. Just recording it, I've seen errors made in just that. So we hold your hand through the process. That's how we work here. I'm probably going more in depth into this than I need to. But the third point is trust funding is an important part of the process if you have a trust, because a trust only controls what it owns. We do planning, not paperwork. I borrowed that from one of my mentors, Paul Yokobitis, out of Cary, North Carolina, although that was really just a waste of oxygen there because you don't care about that. But those are the things that you can think of ahead of your appointment with our office. One, the different tools for estate planning, wills, revocable trusts, and irrevocable trusts. Two, the low-hanging fruit. I went a little bit out of order here. The low-hanging fruit, nominating the decision makers if you can't make decisions for yourself. And three, the fact that trusts must be funded. Your assets must be coordinated with those trusts to get the benefit of them. Those are the three things that if you love learning and you really want to get into this, if you think about those three things ahead of your appointment, you're going to be way ahead of the curve. On behalf of our firm, we are really, and I truly mean this, looking forward to helping. Thanks for watching.